Hi, I'm Ann P. Mitchell, attorney at law, law professor emeritus, and founder of We the People Defend. We the People Defend gives people easy actions to defend democracy using the internet and your voice. You don't even have to leave your house. Join us now at wethepeopledefend.org. Since January 20th, we've had a lot of people ask us, but who will enforce it if he just decides to ignore a court order? First, it's important to note that to date, in the more than 100 lawsuits against Trump and the administration, they have not refused to follow a court order even once. So this is really just future tripping. Don't give him that real estate in your head. Anyways, here's how it breaks down. First, the enforcement arm for the federal courts is the U.S. Marshals Service. The U.S. Marshals serve warrants and subpoenas and make arrests on behalf of the federal courts. In addition, as written right into our federal law, quote, "It is the primary role and mission of the United States Marshals Service to provide for the security and to obey, execute, and enforce all orders of the United States District Courts, the United States Courts of Appeals, the Court of International Trade, and the United States Tax Court, as provided by law." Of course, the U.S. Marshals are overseen by the Department of Justice, which is part of the executive branch. This means that, in theory, Trump could order the DOJ to order the U.S. Marshals to not execute the lawful order of the court. However, there are two things about this. First, disobeying a court order almost has to happen in order for the House to start taking seriously their duty to impeach. Once impeached, the Senate would have to convict in order to remove Trump from the office of the president. We've seen how this went last time, but that was then. This is now. But second, there is a workaround specifically for when a court is being thwarted by the Department of Justice. The court can escalate the charge to criminal contempt. The crime being committed is refusing to follow the court order. At that point, the court can apply to the Attorney General, also in the executive branch, to have an administration attorney assigned to prosecute. And the law very clearly states, quote, "The court must request that the contempt be prosecuted by an attorney for the government, unless the interest of justice requires the appointment of another attorney. If the government declines the request, the court must appoint another attorney to prosecute the contempt." Did you catch that? Must? Must appoint another attorney. Not may, must. So the answer to what can the court do if they simply refuse is they've got ways. Our system of government has zero loopholes for someone to actually be king, no matter what they say. Also, for those of you asking, what about the Supreme Court ruling on presidential immunity? What the ruling said was that the president has broad immunity for official acts within the scope of being the president. Disobeying the law is not a presidential act. In fact, it's the opposite, as the president is sworn to uphold the law. Moreover, while it has never been tested, it is generally understood that the one person that the president cannot pardon is himself. Finally, again, please join us at We the People Defend and help us defend our democracy using the internet and your voice. Go to wethepeopledefend.org.